they file it, you really can't, unfortunately, sit and wait for somebody else to do something else. Because what happens is, it actually, the order can go back as far as the date of service. And that means that once you file the complaint, the court's going to actually mail you a summons, or they might give the summons to the Department of Revenue. And what happens is, if the Department of Revenue doesn't serve that summons on time, then all that time you're actually losing. So what I suggest to my clients is, if you want to file through the Department of Revenue, it's better to pay the extra $35 or $45, get your own constable, serve the other party with that complaint, because the sooner you serve them, the sooner you can actually change the current order and change the amount of child support that you're actually paying. So especially if a person has lost their job, every week's going to count. If they're paying a $300 order, if they're paying a $150 order, the day that it actually gets reduced is very important, because you'll be saving money throughout that whole time. And by the time that it comes to the hearing date, which sometimes may take a month, 2 months, 3 months, unfortunately, you have a lot of money that has accrued during that time that you're going to be looked at to pay back, and you might not have that ability because you're not working.
Right, and
But don't you also have the ability, once you file your complaint for modification, let's say you file the complaint Monday, you get a date to go back in within 21 days, and within that 21 days, you got to make sure the other party was served with 7 days. However, as soon as you file that complaint and give them the notice, you can also ask for a temporary order, which means you can be in court if you use the constable, and I do agree with you, 100%. He'll be in court in 2 weeks. You don't have to wait 21 days.
So it'd be a short order notice that you can put in as far as
it's not a short order. It's a motion on the complaint for modification. Same way if you file a divorce. You file a divorce, you can be in court in a couple of weeks on a temporary order for support, custody, alimony, et cetera, et cetera, et cetera. So you can go quicker. It's better to get a lawyer, you know, all kidding aside.
Now,
that's what he should do, is get a lawyer.
Well,
with 3 jobs, you got to pay $25 a week.
Let me ask you, if a person goes in and files for a modification for reduction of their child support, and we want the actual support to go back from the date of actual service, like you mentioned, should they be writing the word non-prong-tongue on it? Are you familiar with that term?
Of course, non-prong-tongue.
Non-prong-tongue, did I say it right?
It's okay. Send you back to Latin school.
Which is it's a definition of going back to the actual date of the actual service.
We're going to try res ipsa loquitur pretty soon.
Res judicata even.
Now,
we're all set.
We hear a lot in the court systems that the Department of Revenue uses dirty tactics. They will use extortion. Some may go out as far as saying that they extorting people in the court system. We've heard some attorneys mention, well, if you don't have $1,000 today, you're going to go to jail. Now, we established that the judges are the ones that sentence individual people to jail, not the actual DOR representatives, okay? And if they're representing the state for the Title D4 funding for the welfare, then they don't have the right to ask for jail time or threaten anybody with jail time, correct? Do they have that right?
No, not at all. And I believe in 2004, when I was working with the Department of Revenue and also Essex County Probate and Family Court, that issue rose, and I believe that they needed to address it, and they weren't allowed to make those type of statements to people, especially you have people that are worried about going to jail, you have people that are worried about trying to find this money in order to pay the other parent, and sometimes they don't have that money. So sometimes when these statements are made, obviously it's inappropriate, like you said, because the judge is the one who makes the ultimate decision.
And it's kind of difficult for someone, a family member, to want to see their child, their son, their daughter go to jail. So what we're finding is that most of these parents are actually coming up with the actual money. So is that a tactic that is working for the Department of Revenue?
It is, in a sense, but I want to, if I can,
yes,
Hector,
please.
You know, your situation troubled me where they took more money out of him on an arrearage. That means he owed, let's say you owed $5,000, you made a dealer pay $50 a week. But what happened was they found that you got a check for $1,000, so they grabbed the whole $1,000. That's a very interesting problem, because they're entitled to do that. But if he, in his agreement, okay, that you put down no more than $50 a week, now you might be able to sue the department.
Well, mine was a court order.
I know, but in your court order, there should be a stipulation that says it's $50 a week, no more than $50 a week. Not that they can open the floodgates, which is what they did on him. Let me say that's not unusual, especially income tax checks, because it's money owed, okay? Unless he makes it a court order that says it's money owed, but I don't have to pay you more than 50. Because if he doesn't pay the 50, he can go to jail.
Right.
So I see the difference, but I think you got to change the order that stops them from going in and collecting more than $50 a week, if that's the situation. It just dawned on me when he was going through it. I said, that isn't fair, but it happens every day, and we both see that.
Yeah, and we see it a lot too. And I mean, I just like to state that when a court issues an order, whether you're a male or a female, you do have that right to modify that order. If you disagree with the actual order, you have the right to appeal that order as well. Those are steps that people can take as well if they're dissatisfied with a judgment from the court, forcing you to pay an order that you can't physically do after you stated on the record that you don't have the ability to pay. Can those orders be appealed?
What, you're talking about well, is it the complaint for modification and then you get an order for child support, or are you talking about the contempt?
Well, once the actual order is issued for child support and the person does not agree with the actual order, what steps can they actually take?
Okay. With regards to with a child support order, there's this worksheet that that the court and the statute has incorporated that basically punches out a number. And it's a formula that's calculated. It takes into account the gross income, how much health insurance is actually paid, any dental insurance that's actually paid, daycare expenses that are actually paid, how many children, the income of the other party as well. And then a number kind of just spits out. And with that number, that's the number that they typically use. To appeal it, you could appeal that number. However, the likelihood of it changing is not very likely. And I don't know an attorney that would actually waste the time to appeal it, knowing that the statute is usually the number that they always give anyway. So.
The only place to go is the appeals court. They won't even hear you on that. Let's be for real. Right?
Well,
I mean, technically, I do agree with you, Counselor.
But you could.
Practically, forget it.
Right.
Ms. Rodriguez, if anyone out there that is facing child support issues or needs some legal expertise, how do they reach you?
My telephone number is 978-683-0508. My law office is actually in Lawrence on 12 Pemberton Way. We're on Essex Street, and there's a Bank of America building. We're actually on the 4th floor of that building. So you could stop by and see me, and obviously I'll help. And my email address is pretty easy to remember. It's Attorney Joanna Rodriguez, it's kind of long, @gmail.com.
Great, and we've watched you a couple of times in the court, and you're a real sharp attorney. So anyone out there that's looking for a sharp attorney, there she is right there. And if you're looking for another attorney, sharp attorney, Mr. Diffusio, how do people get a hold of you if they needed to reach?
Well, I'm not as sharp as my colleague next to me, but I will admit that it's 978-687-1777, just like the Revolution, 1777, okay? And we've been around for 45 years almost, 43. So we're there.
And we're going to continue to work with you, Mr. Babs, on trying to follow your case and report back to the viewers and let them decide. I want to thank the viewers for watching. I want to thank my guests, Attorney Rodriguez, Attorney Diffusio, and Mr. David Babb. You've been watching Behind the Scenes. Join us next time when we go behind the scenes to ask the tough questions, bring you their responses, and we let you decide. Thank you for watching.